start. In considering whether a public officer is guilty or the misconduct charged against him, the rule followed in criminal trials that an offence is not established rules unless proved by evidence beyond reasonable doubt to the satisfaction of the court does not apply, and even if that rule is not applied, the High Court in a petition under Article 226 of the Constitution is not competent to declare the order of the authorities holding a departmental inquiry invalid. Stop. The High Court is not constituted in a proceeding under Article 26 of the Constitution, a court of appeal over the decision of the authorities holding a departmental inquiry against a public servant. It is concerned to determine whether the inquiry is held by any authority competent in that behalf and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. Stop. Where there is some evidence which the authority entrusted with the duty to hold the inquiry has accepted, and which evidence may reasonably support the conclusion that the delinquent officer is guilty of the charge, it is not the function of the High Court in a petition of writ under Article 226 to review the evidence and to arrive at an independent finding on the evidence. Stop. The High Court may undoubtedly interfere where the departmental authorities have held the proceedings against the delinquent in a manner inconsistent with the rule of natural justice or in violation of statutory rules prescribing the mode of inquiry, or whether the authorities have disabled themselves from reaching a fair decision by some considerations extraneous to the evidence and the merits of the case, or by allowing themselves to be influenced by irrelevant considerations, or where the conclusion on the very fact of it is so wholly arbitrary and capricious that no reasonable person could ever have arrived at that conclusion, or on similar grounds. Stop. But the departmental authorities are, if the inquiry is otherwise properly held, the sole judges of facts, and if there be some legal evidence on which their findings can be based, the adequacy or reliability of that evidence is not a matter which can be permitted to be canvassed before the High Court in a proceeding for a writ under Article 236 of the Constitution. Stop. In a petition under Article 226, High Court is not a court of appeal over the discussion of the departmental authorities. Stop. It is not the function of the High Court to review the evidence and arrive at an independent finding on evidence. Stop. Departmental authorities are the sole judges of the facts if inquiry otherwise properly held. Stop. Over.